Good morning. Earlier today, the Department of Justice, joined by 29 states and the District of Columbia, sued Live Nation Entertainment and its wholly owned subsidiary, Ticketmaster, for violating the Sherman Antitrust Act. In recent years, Live Nation Ticketmaster's exorbitant fees and technological failures have been criticized by fans and artists alike. But we are not here today because Live Nation Ticketmaster's conduct is inconvenient or frustrating. We are here because, as we allege, that conduct is anti-competitive and illegal. Our complaint makes clear what happens when a monopolist dedicates its resources to entrenching its monopoly power and insulating itself from competition rather than investing in better products and services. We allege that Live Nation has illegally monopolized markets across the live concert industry in the United States for far too long. It is time to break it up. Live Nation Ticketmaster has made itself ubiquitous in the live entertainment industry. It controls at least 80% of primary ticketing at major concert venues. It directly manages more than 400 artists and controls more than 60% of concert promotions across the country. And it owns or controls more than 60% of large amphitheaters in the United States. We allege that to sustain this dominance, Live Nation relies on unlawful, anti-competitive conduct to exercise its monopolistic control over the live events industry in the United States and over the fans, artists, independent promoters, and venues that power the industry. The result is that fans pay more in fees, artists have fewer opportunities to play concerts, smaller promoters get squeezed out, and venues have fewer real choices for ticketing services. As detailed in our complaint, Live Nation Ticketmaster locks out competition in ticketing through the use of long-term, exclusive ticketing contracts with venues that can last over a decade, as well as by acquiring venues themselves. With exclusive agreements that cover more than 70% of concert ticket sales at major concert venues across the country, Ticketmaster can impose a seemingly endless list of fees on fans. Those include ticketing fees, service fees, convenience fees, platinum fees, price master fees, per order fees, handling fees, and payment processing fees, among others. For fans in the United States, this illegal conduct means higher prices. In other countries, where venues are not bound by Ticketmaster's exclusive ticketing contracts, venues often use multiple ticketing companies for the same event, and fans see lower fees and more innovative ticketing products as a result. We also allege that Live Nation Ticketmaster uses these long-term ticketing agreements with venues and its control over those venues to unlawfully pressure artists into agreeing to use its promotion services. In fact, Live Nation often sacrifices profits it could earn as a venue owner by letting its venues sit empty rather than opening them to artists who do not use Live Nation promotion services, even during peak concert season. Live Nation has not only deployed anti-competitive tactics to coerce artists and venues into using its services and to charge fans excessive fees, it has also worked strategically and illegally to eliminate the threat of potential rivals from emerging across any of its businesses. As detailed in our complaint, Live Nation suffocates its competition using a variety of tactics, from acquisitions of smaller regional promoters and venues, to threats and retaliation, to agreements with rivals designed to neutralize them. This has included acquiring or co-opting key independent promoters, even when the economics of a particular deal did not make sense for Live Nation's promotions business. For example, as recounted in our complaint, Live Nation acquired a controlling stake in AC Entertainment, an independent promoter in Tennessee. Live Nation's chief strategy officer assured executives that even though, quote, the numbers are not super exciting and this feels like more of a defensive move, the acquisition helped, quote, grow our moat in the Nashville market. When faced with another potential competitor to its promotions business, Live Nation took action to ensure that the competitor would not threaten its dominance in the live music industry. Live Nation initially categorized that competitor, the venue operator, Oakview Group, as one of its, quote, biggest competitor threats. Over time, however, Oakview and Live Nation morphed from competitors into partners. As detailed in our complaint, Live Nation executives repeatedly scolded Oakview for trying to compete. In one instance in 2016, Live Nation's CEO warned Oakview that competition would only lead to artists demanding more compensation. The Live Nation CEO emailed Oakview writing, quote, let's make sure we don't let them now start playing us off, referring to a prominent artist agency. Oakview backed down. In a similar instance in 2022, Live Nation's CEO scolded Oakview's CEO, quote, who would be so stupid to do this and play into the artist agent's arms, close quote. Oakview again backed down, quote, we have never promoted without you, won't, said its CEO, and later added, quote, I never want to be competitors, close quote. We also allege that Live Nation has repeatedly wielded its powers to keep its rivals from expanding in the U.S. concert promotions market through threats and retaliation. In 2021, Live Nation threatened to retaliate against private equity firm Silver Lake unless one of the latter's portfolio companies, TEG, stopped competing with Live Nation for artist promotion contracts in the United States. Live Nation's CEO told Silver Lake that he, quote, failed to understand why Silver Lake, quote, continued to invest in a business that competes with Live Nation, close quote. The threats ultimately succeeded, and Silver Lake has tried to sell TEG altogether. We allege that Live Nation does not maintain its dominance in the live entertainment industry by staying ahead of its competition on the merits. It does so by unlawfully eliminating its competition. We allege that Live Nation controls the live entertainment industry in the United States because it is breaking the law. I am grateful to the Justice Department's Antitrust Division for their excellent work on this case. The live entertainment industry is complex and well-sourced. Taking on this case has required persistence and diligence by the antitrust lawyers who are behind me today and by their team. I am proud to work with them. People always remember the first time that they were transformed by live music. I still remember, as a senior in college, going to a Bonnie Raitt concert and seeing a then up-and-coming musician named Bruce Springsteen play as a warm-up act. We all knew that we had just seen the future of rock and roll. The Justice Department filed this lawsuit on behalf of fans who should be able to go to concerts without a monopoly standing in their way. We have filed this lawsuit on behalf of artists who should be able to plan their tours around their fans and not be dictated by an unlawful monopolist. We have filed this lawsuit on behalf of the independent promoters and venues which should be able to compete on a level playing field. And we have filed this lawsuit on behalf of the American people. It is time for fans and artists to stop paying the price for Live Nation's monopoly. It is time to restore competition and innovation in the entertainment industry. It is time to break up Live Nation Ticketmaster. The American people are ready for it. Thank you. I'll now turn this over to the Deputy Attorney General.
Good morning, everyone, and thank you, Mr. Attorney General. Today's announcement reflects the latest efforts by the Department of Justice to combat corporate misconduct. Since day one of this administration, we have prioritized holding the most serious corporate wrongdoers accountable, from bribe payers to money launderers to price fixers. Our fight against corporate wrongdoing includes an intense focus on anti-competitive conduct, which disadvantages consumers, workers, and businesses of all kinds. As the Attorney General detailed, today's announcement alleges that Live Nation and its subsidiary Ticketmaster have engaged in anti-competitive conduct to cement their dominance of the live concert market. It lays out how Live Nation Ticketmaster acts as the gatekeeper for an entire industry, reaching its proverbial hands into every stage of the concert life cycle, from who promotes the shows to where they happen to how they are ticketed. And with its exclusionary conduct, Live Nation effectively reaches into the pockets of concert goers by driving up fees. Over the years, Live Nation has intentionally blocked others out of the market, limiting where shows can take place, who can sell tickets, and who benefits from them. As alleged in the complaint, they've employed a range of tactics to keep competitors out of the market. Long-term exclusive ticketing contracts, serial acquisitions of regional competitors, and threatening to retaliate against venues. Today's lawsuit by the Justice Department's Antitrust Division is an enormous step forward in preventing one company from dictating the ebbs and flows of an entire industry. It's a step forward to give more venues, promoters, and ticket sellers a chance to compete for the biggest shows. And it's a step forward in making this era of live music more accessible for the fans, the artists, and the industry that supports them. Because when families want to attend a concert, the add-on fees they need to pay shouldn't break the bank. When an independent venue wants to host the next big show, they should have the opportunity to compete. And when a regional promoter wants to publicize an artist, they shouldn't have to fear retaliation. Put simply, one company should not have the power to determine who gets to participate in a marketplace. I want to thank the women and men of the Antitrust Division for their work, and Assistant Attorney General Cantor for his leadership to protect consumers, performers, and small businesses. Today and always, their work forms part of the foundation of the Department's corporate enforcement mission: to promote fairness, to drive deterrence, and to advance the rule of law. Thank you. And with that, I'll turn it over to Assistant Attorney General Cantor.
Thank you, Attorney General Garland and Deputy Attorney General Monaco. The live music industry in America is broken because Live Nation Ticketmaster abuses its illegal monopoly. Today, the United States and 30 state attorneys general filed an antitrust lawsuit that seeks to restore competition by breaking up Live Nation Ticketmaster. The recipe for live music includes three key ingredients: artists, venues, and fans. Live Nation Ticketmaster's dominance has allowed it to exert control over all three. It starts with power over artists. Today, Live Nation Ticketmaster represents hundreds of artists through its dominant promotions business, which controls the organizing, marketing, and financing of large concerts. Live Nation Ticketmaster also owns or controls venues at which these concerts are held. For example, it owns 60 of America's 100 large amphitheaters. At these venues, Live Nation Ticketmaster not only earns money from tickets and fees, but also from concessions, merchandise, sponsorships, and even parking. And through its Ticketmaster subsidiary, Live Nation controls primary ticketing at hundreds of other venues across the country. And it is through these exclusive ticketing arrangements that Americans face the dreaded Ticketmaster tax. the seemingly endless set of fees, ironically named service fee or convenience fee, when they are anything but. Our lawsuit explains through detailed allegations how Live Nation Ticketmaster weaponized and entrenched its power at the expense of artists and music fans across the entire country. Just by way of example, the lawsuit alleges how Live Nation Ticketmaster sought to avoid expensive bidding wars that would have returned more money to performers. This is bad news for all artists, but it is especially bad news for working musicians who do not have the power to fight back. Despite its already massive size and power, Live Nation Ticketmaster has acquired even small and regional promoters that Live Nation feared could one day threaten its dominance. As the complaint also alleges, Live Nation Ticketmaster threatens and retaliates against venues that try to choose a different promoter or ticketer. If you're an artist, you understand what's at stake. Use Live Nation for promotion or risk being locked out. In its own words, Live Nation uses its exclusionary conduct as a, quote, hedge against significant improvements by the competition or even a new competitor, end quote. But the cost of that hedge is one that we all pay. For example, a broken ticketing website with substandard customer service that still captures your valuable data. As Ticketmaster has said, quote, now we not only know the person that bought the ticket, but also the 3 people that you are taking to the show. Each of these acts are unlawful on its own, but taken together, they're even worse. Collectively, these practices forge an impenetrable corporate barrier around the live music industry. That is why, with today's lawsuit, we seek to hold Live Nation Ticketmaster accountable for violating the antitrust laws. The legendary songwriter Harlan Howard famously described American music as 3 chords and the truth. This is more than just a clever turn of phrase. It speaks to the importance of music to free speech and the public discourse. Mr. Howard was right. Words and music come together to create one of our country's most cherished forms of free expression. Music is the soundtrack for our lives. As a country, it is how we communicate about politics, love and despair, spirituality, humor, pain, joy, and everything in between. It is here, there, and everywhere. Live music should not be available only to those who can afford to pay the Ticketmaster tax. We are here today to fight for competition so that we can reopen the doors to the live music industry for all. In closing, I would like to thank the Antitrust Division and the staff who today are the rock stars performing to the delight of an entire nation. I would also like to thank the Attorneys General and their amazing staffs from the states of Arizona, Arkansas, California, Colorado, Connecticut, the District of Columbia, Florida, Illinois, Maryland, Massachusetts, Michigan, Minnesota, Nevada, New Hampshire, New Jersey, New York, North Carolina, Ohio, Oklahoma, Oregon, Pennsylvania, Rhode Island, South Carolina, Tennessee, Texas, Virginia, Washington, West Virginia, Wisconsin, and Wyoming. They join us today in filing this important and historic case. Thank you.
Question here. One on topic and one off topic. I don't know who can answer the question, but when we talk about the Ticketmaster tax and these add-on fees, are we talking about tens of dollars or hundreds of dollars in terms of the average consumer?
It's a good question, which I'm going to give to Mr. Cantor.
I think you need to ask consumers what they think of the taxes that they're paying and the fees that they're paying. the end of the day, in the aggregate, this amounts to billions of dollars in value across the entire country and across the entire industry.
Mr. Attorney General, with information coming out that the Supreme Court Justice has had a flag associated with the Stop the Steal movement flying over his property, and with two January 6th related cases before the court, do you have any concerns, and is there anything the Justice Department can do or say about the situation?
As you rightly point out, the Justice Department has cases before the Supreme Court, so I can't comment on any justice.
We rarely see the DOJ at this phase of enforcement clearly state what kind of remedies it would be looking for in terms of an antitrust case. In this case, however, it's very clear that the DOJ is seeking to break up Ticketmaster, Live Nation. Why did you decide to make this so clear at this moment in time, and what kind of remedy or potential breakup would satisfy basically the thinking of the DOJ in this case?
Well, I'm going to leave the fuller answer to the Assistant Attorney General, but as the complaint describes, Ticketmaster is an important element in the gears. I think they describe it as the flywheel of the operation, and it's necessary to separate Ticketmaster from Live Nation to limit the overall dominance of the industry and all the effects on consumers, fans, promoters, artists that we talked about. But I'm going to let Jonathan say more.
Some monopolies are just so entrenched and some problems so difficult to address that they require decisive and effective solutions. We request a remedy that has been used in antitrust law going back over 100 years, which is structural relief.
Next question, Glenn.
I have two questions for the Attorney General, neither of them on topic.
I'm surprised.
I got most of us got a solicitation email this morning from the former President of the United States saying that the Justice Department had authorization to kill him during the Mar-a-Lago raid. First, can you give us some clarification on that particular point that he's making, and whether or not deadly force is authorized in other interventions, including the search of Mr. Biden's residence and office? And the second question is,
Can I do one at a time? Okay. On that one, that allegation is false, and it is extremely dangerous. The document that is being referred to in the allegation is the Justice Department's standard policy limiting the use of force. As the FBI advises, it is part of the standard operations plan for searches, and in fact, it was even used in the consensual search of President Biden's home.
The second question is, obviously the House appears poised to move ahead with contempt resolution on you. I just wonder if you have any comments on it, or if you could tell us whether or not you watched the House Oversight Committee meeting the other night.
I caught part of that hearing on Saturday Night Live. But seriously, I am very disappointed. The Justice Department, as I've explained before, has gone to extraordinary lengths to accommodate the legitimate interests of the committees. I have released the full and unredacted report of Mr. Herr. We permitted Mr. Herr to testify for over 5 hours on everything that happened in connection with this investigation, and we provided the transcripts of the interviews in which the committee is interested. But on the other side, the President of the United States has asserted executive privilege in order to protect the Justice Department's ability in future investigations to get cooperation in high-profile cases, particularly involving the White House. My job is to protect the Justice Department's ability to conduct those investigations. My job is to protect the rule of law, and that's what I'm doing.
Last question, Caitlin. General Garland, I have two questions. The first was the Justice Department approval of the Live Nation and Ticketmaster merger back in 2010 a mistake? And then a different topic.
Let's do one at a time.
Okay.
Unless they're both
No, I have
on topic, in which I'm going to punt them to Mr. Cantor anyway. Is the other one also on topic or off topic?
It's a different topic.
Okay, so on that one, I think our complaint adequately describes the reason why that did not resolve the matter as far as we are concerned, but I'm going to let Mr. Cantor say a little bit more, and then I'll come back for you.
The previous action involved one transaction. The current action involves a systemic and systematic pattern of anti-competitive conduct that addresses nearly every aspect of the live music supply chain. The previous action involved the Clayton Act, specifically Section 7 of the Clayton Act. The current action involves the Sherman Act, monopolization under Sections 1 and Section 2 of the Sherman Act.
And then, General Garland, the Justice Department has said that in court multiple times that voters deserve a quick resolution to the cases against Donald Trump. If that does not happen and there is not a resolution or any trial before the election, would that be a failure of justice?
The Justice Department's position is to seek a speedy trial. That matter is now in the hands of the courts. I'm not going to speculate any further.